If you've created a trust as part of your estate plan, that's a great first step. But in Minnesota, one of the most common estate planning mistakes that we see is that people forget to properly transfer their real estate into the trust. Today, we're going to talk about two different tools that are commonly used in Minnesota to convey property to a trust: quitclaim deeds and transfer on death deeds. We'll explain how each one works, when they're typically used, and what you should watch out for. Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz law firm, where we've been assisting families with wills, trusts, and probate for over 3 decades. In Minnesota, creating a trust does not automatically move your property into it. For real estate to be controlled by your trust, the title must either be transferred to the trust during your lifetime or set up to transfer to your trust at your death. That's where these deeds come in. First, let's talk about quitclaim deeds. A quitclaim deed is the most common deed used in Minnesota to transfer property to a revocable living trust. When you use a quitclaim deed for trust funding, you're essentially transferring the property from yourself as an individual to yourself as trustee of your trust. This transfer happens immediately. Once the quitclaim deed is properly signed, notarized, and recorded with the county, the trust becomes the legal owner of the property. This approach is often preferred when you want the trust to fully control the property during your lifetime. That can be important for incapacity planning, property management, and ensuring the property avoids probate. In Minnesota, quitclaim deeds must be recorded with either the county recorder or with the register of titles, depending on whether the property is abstract property or Torrens property. Filing in the wrong office or using the wrong legal description can create serious title issues. Another important point is homestead property. Transferring a homestead into a revocable trust is generally allowed in Minnesota without losing homestead status, but the deed must be drafted correctly and the trust must meet the statutory requirements. Now, let's talk about transfer on death deeds. Minnesota allows transfer on death deeds under Minnesota state law. A transfer on death deed lets you name a beneficiary who will automatically receive the property when you pass away without going through probate. That beneficiary can be your trust or it can be another individual. Unlike a quitclaim deed, a transfer on death deed does not change the ownership during your lifetime. You remain the owner of the property and you keep full control. You can sell the property, mortgage it, or revoke the transfer on death deed at any time. The transfer only takes place after your death. This can be appealing to Minnesota homeowners who want to avoid probate but who are not ready to retitle the property into their trust during their lifetime. However, there are important limitations. Transfer on death deeds must be recorded during your lifetime, and Minnesota law has very specific statutory requirements on how these deeds are written and executed. Even small errors can invalidate the transfer. Also, a transfer on death deed does not provide incapacity protection. If you become incapacitated, the trust has no authority over the property unless additional planning, like a power of attorney, is in place. So, what's a better option in Minnesota? And I'll give you that famous attorney answer that everybody absolutely hates. Well, it depends. A quitclaim deed is often the better option if you want your trust to fully control the property during your lifetime, especially for incapacity planning and long-term management. A transfer on death deed may be appropriate if your main goal is to avoid probate and if you want to keep the property in your individual name while you're alive. We also need to consider whether there is a current mortgage on the property, as most mortgages do have an acceleration clause. It's also important to consider Minnesota-specific issues like homestead classification, property taxes, mortgage requirements, and title registration. While many trust transfers are not considered taxable sales, mistakes can still trigger problems with lenders or insurers if they're not handled properly. The key takeaway is this: trusts only work when they're properly funded, and in Minnesota, real estate transfers must be done with care. At the Yanowitz law firm, we help clients decide whether a quitclaim deed, a transfer on death deed, or another strategy is the right way to convey property to a trust, and we make sure it's done correctly under Minnesota law. If you own real estate in Minnesota and have a trust, or are thinking about creating one, we encourage you to speak with an experienced estate planning attorney before transferring property on your own. Thanks for watching, and be sure to subscribe to our YouTube channel to find out when we post more videos. Thanks. Have a great day. Bye.